you, Fahira. Good afternoon, good evening, good morning. As Mohammed just said, one of the changes we've all learned from the COVID, reacting to COVID, is we've got international audiences. So hopefully I've covered every time zone. I'm not Gary Bourne, and Gary apologizes for not being able to be here. He also told me to say he's looking forward to coming in person in the future, although now, having heard Lucy, I'm not sure we should all be saying we're coming in person next year. Maybe we need to think more about that. But I do think one of the things we've learned as we've dealt with the initial stages, and I think Mohammed said this is the first chapter, and I think that's really important to think about. We're in the first chapter, and we're learning lessons all the time about how to deal with the pandemic, and that creates opportunities, and it also creates lessons to learn to do things better, but also how to avoid doing things worse. One of the things we need to focus on then is both sides of the coin. And what I hope to do as I talk about this is to talk a little bit about both sides. How do we do things better, and what do we do to avoid making things worse? Now, Gary's talk, as you can see in the program, was called International Arbitration in COVID, Is Spring Coming? It's a positive sounding title, although it's written in the form of a question. And it's a positive sounding title based on a terrible event, a global pandemic. And I'm always cautious about trying to find positives in something as terrible and something that's ongoing like the pandemic. But as Lucy and Mohammed have already demonstrated, we are learning lessons from international arbitration's response to the pandemic. And those lessons help reaffirm and encourage some of the best characteristics of international arbitration. Before I highlight a few of those, I want to give some background context on Gary's title. His question, whether spring is coming, was really a reaction to his own recent theme, including his Freshfields lecture a couple of years ago, that winter is here for international arbitration. Winter follows summer, and Gary had said we've had a long, productive summer during which international arbitration has flourished. So why did he see winter? I'll let you watch, and again, with the theme being technology, watch or read his lectures on this. But I think the concern that winter was here starts with reactions to criticisms of international arbitration, and particularly with criticisms in some cases of investment treaty arbitration, which lead to potential responses which would take power from parties and give power to governments, to states, or to things that look an awful lot like states or transnational governmental institutions. And those include examples to use investment courts created by governments, to eliminate party appointment of arbitrators and hand that function over to institutions, to create institutions that might regulate the conduct of lawyers participating in international arbitration. And the concern with those sorts of approaches is that they may obscure or damage the benefits of international arbitration. And so, for better or worse, I think the reaction we've seen to international arbitration during the pandemic has reinforced in a positive way, and in fact enhanced many of the characteristics that make international arbitration attractive and useful, and indeed often preferable to transnational litigation. And of course, as winter follows summer in Gary's theme, spring also follows winter. And I do think we are now in the somewhat remarkable situation of seeing in a pandemic reasons to think that some of the concerns we had about international arbitration might be lessening, and reminders about the opportunities that we have to continue to help arbitration evolve in a way that makes it an attractive choice to users. When Gary refers to 5 E's, Lucy referred to 3 E's. He refers to 5 E's when he identifies the benefits of international arbitration compared to litigation. And if he was here today, he would have told you there was a 6th E. Gary's 5 E's, and I want to talk a little bit about how these relate to lessons we've learned from the pandemic. But Gary's 5 E's are efficiency, and Lucy talked a bit about efficiency. I want to come back to efficiency and talk about some of what we've learned and some of the ways we might address and use international arbitration to create greater efficiencies from using technology, as we've all started to embrace during the pandemic. But efficiency, expedition, and Lucy talked a little bit about expedition. I want to come back and talk about that a little bit as well. Expertise, even-handedness, enforceability of dispute resolution agreements, and enforceability of awards. And his 6th E, those were his 5 E's. His 6th E is the new E is electronic. And that's the theme today, using technology and how the use of technology may help enhance those traditional 5Es that we say are the benefits to international arbitration. And so let me come back and make some observations for a few minutes on how the lessons we've learned during the pandemic create optimism and help us find in those 5Es hope for evolution in the way we approach arbitration, so that we're continuously making arbitration more responsive to user needs, more effective, and therefore an option that works for a wider audience. So, and the first point I want to talk about briefly is this idea of efficiency. And what that stands for, I think, often is the idea that we can customize or use the inherent flexibility in international arbitration to create something that works better for users than a national court litigation does. And I think one of the issues that we've heard already as a theme from the very first moments today are the fact that we need to reconsider habits, that we need to think in terms of change, that we need to think about making sure we overcome ways of doing things that are reflexive and not thoughtful. And one of the ways I think we see the use of technology helping us think about that is the fact that it has in some ways forced change. And this comes to, I think this pulls together some of the various themes that Lucy and Mohammed have already raised, because one of the things we saw before the pandemic, when people talked about using technology, we often got a response that it was okay in the abstract, but in reality, it didn't work. And frankly, maybe I'm talking out of turn, but I just before the pandemic, I was in an editorial board meeting with a number of very well-known, and I'm trying to think of where they would fall in Mohammed's list of the generations, not in Generation X. Let's put them older than Generation X. And the topic had come up whether or not that particular journal should focus on the use of technology, in particular to address environmental concerns. And what you got was lip service for about 5 minutes around the idea that technology could be useful. And then pretty quickly, all of these gray-haired arbitrators saying, well, you know, I had a case recently where you couldn't have used a remote hearing because it really was about the credibility of witnesses, and you really need to be in the room to see the witnesses. You couldn't have done that case without being in person with the witnesses. Therefore, I don't think I like using technology. Or you'd get the reaction, well, I had a video conferenced witness recently and there was a lag or there were technical problems with the video conferencing. And therefore, it might be good in the abstract, but I don't think it works. What we've seen through the pandemic, obviously, is a lot of people being forced to, because they have no other option, to revisit that. And what you have is a lot of people who are historically hostile and really would have not revisited the use of technology, now embracing it. So I think that's in some ways where we see small shoots of leaves, and we see spring coming is the forced confrontation with old habits. In terms of expedition and the benefit that arbitration offers compared to litigation, one of the things we see statistically is that international arbitration cases are going forward. Most institutions are reporting no real drop off in the number of cases. Most institutions are reporting, I think anecdotal evidence is clear that in most cases, there might have been short delays to rearrange hearings in cases that were coming to hearing to deal with the impact of the pandemic, but cases are going forward. And in contrast, what we're seeing is the backlogs in national courts are not getting better, they're getting much worse. And so here's a place where the benefits of arbitration, the ability to go forward, to adapt to the challenges by using technology, has put arbitration in a much better position than state courts are in dealing with the challenge of going forward and dealing with the contrast to backlogs in state court cases. What we're also seeing, I think, is the international arbitration community at the same time, particularly institutions dealing with the challenges of cost. Lucy raised some of the challenges of cost, but one of the ways we see institutions dealing with that is to implement new rules for expedited procedures, for early determination, for emergency arbitration proceedings, all things meant to make cases move forward faster, and particularly with expedited procedure rules, to make cases move forward on a cheaper basis. And frankly, those cases can very much be enhanced by the use of technology to create, maybe for the first time, a real cheaper and expeditious alternative to court proceedings for a wider range of disputes. I'm not going to spend time on expertise. I do think that everyone understands that one of the potential benefits of arbitration is picking decision makers who are appropriate to the particular dispute. And Lucy and Mohammed both have talked about how technology is hopefully opening up the choices people are making to a wider audience, that people are seeing different characteristics being important to who they're choosing as arbitrators, the visibility and familiarity that arises from the sorts of events we're talking about, but also the use of technology, which brings more people into it, means that not only are we picking people who maybe are more expert than local courts may be, but we're bringing hopefully a wider range of people into that choice. I'm not going to spend time on even-handedness, the notion that arbitration compared to local courts apply neutral rules, neutral appointing authorities, and that and I'm not really going to comment on enforceability. I want to come back to enforceability in a minute. I want to jump into some of the specific issues that get identified when people start to talk about benefits and concerns about the use of technology, particularly around hearings. And I wanted to pick up a few of the random points that have been made before and maybe wrap up with a few practical observations. And one is, Lucy talked about the environmental impact of arbitration. And we also often see people talk about the potential positive cost implications of using technology to avoid as much travel and as many remote hearings. And I think that there's been a backlash in places where people have been saying, well, wait a second, you may be saving costs. This isn't so much an environmental issue, but this is a cost issue. You may be saving costs because you're saying people don't need to travel or stay in hotels, or maybe fewer people need to travel. But you're ignoring the fact that there may be many greater costs that are imposed when you use technology. And some of that is perhaps shifting all of the evidence into electronic form, although I think suggestions that that's a huge cost is overblown. But one of the things we have to handle if we want to take advantage of technology is how do we use technology in a cost-effective way? How do we use electronic evidence, electronic bundles, hyperlinking in ways that are cost-effective? But the particular criticism is if you have shorter hearing days or hearing days that have to be either because of concerns about the concentration of the participants or because of time zones, as Mohammed was talking about, chopped up in different ways, are you actually potentially extending the length of hearings and therefore increasing the most important driver of costs, which are legal fees and arbitrator fees? And the answer to that, of course, is being thoughtful about it. So there can be cost savings. There can be huge cost savings by using technology, and you just need to be thoughtful that when you use that technology or when you do things remotely, you're doing it in ways that are not going to increase your costs, and it creates an opportunity to be efficient rather than an accidental inefficiency. One of the other criticisms that we sometimes hear of remote hearings or the use of technology is that it makes witness testimony and oral arguments less real, that the reaction of the tribunal, the reaction of the examining lawyers, the reaction of witnesses are affected by things like screen views and different camera angles and microphones and backgrounds and the quality of image. And there's this notion that you really need to have nonverbal communication. You need to read the demeanor of witnesses. And I actually think Mohammed's point earlier about generational change is part of the answer to this. Part of the answer is that as younger people, and I hate to make it a nation, but as younger people get more used to talking, communicating with their friends, with their loved ones, doing business through technology, the notion that you can't read a witness, you can't read a person sort of falls away because it's a matter of familiarity. And I also think the initial negative reaction often comes from people who've done it once or twice. It's been cumbersome and unfamiliar. And they then want to quickly write it off and say, I don't want to do it that way, when in fact, it just takes a little time to get used to a new way of doing things. And undergirding all of this is a really important false assumption that we as human beings know how to read other human beings through nonverbal cues, which empirical study after empirical study says isn't actually very true. So maybe what it's doing, to the extent it is making it harder for us to rely on those intuitive reactions, is getting us away from false bases to make decisions. There's also criticisms about how the use of technology may tell people that arbitration is a less formal process, and therefore it should be taken less seriously. And I think it's really important to remember that one of the key bases and the key strengths of arbitration is enforceability. And so it's incumbent upon all of us to educate our clients, the parties in front of us, whatever our role is in the procedure, on the fact that what we get through in arbitration is a process where the agreement to arbitrate and then any award is more enforceable than in a national court proceeding is going to be in most places. But also the fact that we have something that might be a more informal process isn't something that says creates less of a binding or enforceable outcome. And therefore, while there may be some misunderstanding, and that someone could argue the use of technology helps foster, the reality is the great benefit of international arbitration is its ultimate finality and enforceability, and remote hearings shouldn't change that. And what remote hearings should do is increase accessibility to people who otherwise aren't necessarily able to travel to or attend or use court proceedings. And in a lot of parts of the world, technology may overcome issues that have kept people out of a dispute resolution process historically because of the difficulty created by distance, time, and travel. Really briefly, I want to wrap up, and I know I've been jumping around a bit, but I was trying to pick up on points that Lucy and Mohammed made. I want to finish up with coming back to this idea of efficiency, flexibility, and customization. And say, I think the real impact that the pandemic should have on us is to make us rethink, again, coming back to this idea of reconsidering habits, rethink how we approach cases, and to give more thought to whether and how we incorporate technology in our proceedings, including some form of remote hearing from the start of a case. Right now, we're still dealing with cases that were already up and running when the pandemic started, but how do we use technology from the start of the case? And that may mean rethinking how to structure and sequence the steps in a case, including the assumption that many people seem to have that every case should build up to a last step, which is a potentially lengthy hearing, and that we don't have hearings earlier. So one of the ways to rethink this is to ask the question, do we need to address all legal and factual issues in some sort of comprehensive written submissions and then holding a single hearing to address all the merits issues? But whether we can use technology in order to structure the timetable so that perhaps we break issues up into distinct factual and legal issues, which can be addressed separately and maybe earlier in the case. And it may be a way we can, because we don't have to fly arbitrators to one place, we can use people in different locations because we're using technology, and we can maybe dispense with a particular issue or a subset of issues through a different approach, both to hearings, but also to more focused written submissions, using a mixture of shorter remote and in-person hearings, not just hybrid hearings, but breaking hearings up to be subject-specific hearings, maybe done smaller, quicker, shorter at earlier times in the cases, where we hear arguments or testimony relevant to a particular issue. And then if we do that, and if we use technology, we also may be able to better allocate the focus on key issues. And one cheap example is, many people will have been through week-long or multi-week hearings where the quantum experts end up testifying for a few minutes at the very end because the parties have run out of time. Well, if we really think about how to use technology and we divide up what needs to be done in person, what can be done remotely, and think about doing things at different times, you might be able to really give that sort of testimony the attention it deserves, rather than shoehorning it into that week you've allocated to yourself when you all come together physically. Now, all of these approaches can create inefficiencies, and so the overarching theme has to be smart about all this, to think about where can we use technology to get benefits, and to make sure that we're not falling back onto old habits and old ways of doing things, and letting people who say, oh, I did that once and didn't like it, or it was unfamiliar, or the Zoom crashed, means that we don't continue to rethink how we do arbitration each time we enter into an arbitration, and we don't think about how do we use all the available techniques, technology, and procedural opportunities to efficiently deal with this particular case in front of us in a way that's efficient and fair for this particular case. The lack of comfort with or lack of familiarity with technology can't be an excuse to avoid change. What we need to be doing is making sure that arbitration continues to be a better option than court litigation. And to do that, we ultimately need to grab that flexibility. I'm using an F rather than an E, but that flexibility that undergirds this idea of expedition and efficiency. And technology is teaching all of us new ways to do that. And so I'll stop at that point, and let us go to questions.